Hi. Welcome. Go ahead and take a few minutes, settle in. We're going to give people time to come back in. I see you there, Clarissa. I see you. I see you. We did a part one legal live on Instagram earlier today, and this is basically the continuation from it. We're doing it on two different platforms, specifically because many people do not have Instagram and wanted to have a second option to catch the legal live. So this is the second option. And once this is done, I will save this. I did a test run not too long ago to make certain that YouTube was up and running and functional. It looks like it is. So we'll be doing this. It's a full day of class today. Learning is definitely fun. Yeah, absolutely. We're going to give, like I said, everyone a few minutes to see if anyone's coming in. I have a list of questions that were already sent to me. So we're going to try to stick to those questions and answer them, and if possible, do a rather brief live, given the fact that I already did 2 hours of legal live on Instagram before today. So if humanly possible, try to keep this version shorter. But first, I give people time to come in because I see them rolling in. Hello, everyone. Here, there is a chat available. You can say hi. You have questions, you can go ahead and type them in. I already have a list of questions that were sent to VLM or sent personally to me or to Mr. R. So we've got a list of questions ready to go already. But if you are here and you have not had a chance to ask your own question or haven't sent them in before, feel free to type it into the chat box and I will definitely attempt to get to yours. It's always a great idea to type yours in before it gets overcrowded, and that way yours gets answered early on. So okay, so I'm going to actually just give it one more minute. After that, I'm going to get started. So if anyone comes in later, they can rewatch if necessary. But I'm going to pull up two lists of my questions because I've received questions from various platforms. So here we go. Let's pull up my set. All right, so the very first question that I will answer, because this is a part two of the legal live, has to do with SR related questions. So here's one, and it's specifically for, the 24th hearing. There's actually a lot of questions. Okay, so the first one I'll get to is very simple. It's going to kind of help tie together and transition from the last live to this live. So again, this is part two of the legal live that we started on Instagram, and the third hour of it. So okay, so the very first question that I'm going to answer is a transition question. It's going to help out really well. On Instagram, we talked about the trial itself. There was a lot of trial related questions, a lot of questions related to what are SR's options at this time, his ability to sue, his ability to possibly come back as an entertainer. We also discussed specifics as far as, did he know that he would be cross-examined by the prosecution? And if he did not, did that mean he was unprepared? So this first question is directly related to that part of the questioning. It's basically saying that if he was cross-examined, if SR was cross-examined, and he did not know ahead of time that he was cross-examined, does this mean he was caught completely unprepared? And if he was caught completely unprepared, did that affect his performance at the hearing? So it's very much related to what we covered during the last live. The answer is very similar to it, but it'll definitely help us bridge and get back in here. As we talked about, being caught unprepared for the cross-examination is true. His lawyer expressed that they were not aware of it because in South Korean legal system, you actually have to let them know, yeah, hi, I want to cross-examine. But when you don't know that, they could have assumed they're not interested. So yes, it was a surprise. However, as I explained earlier, being surprised does not equal to being unprepared, because we often as lawyers prepare our clients to expect the unexpected. What happens when something unexpected happens? How do you answer a question that you are unprepared for? So those coming in, hello, hello. So how do you answer a question you're unprepared for? So he has basic training on how to handle these kind of situations. Surprised, perhaps, but completely unprepared? No, he knows how to handle unprepared. He might have been, but he knows how to handle these questions that he did not practice ahead of time with, or perhaps that were ridiculous, and he didn't think it would be related. He knows how to handle those. Would it have affected his performance at court? Now, this one I can tell simply by the way he responded to all the rest of the hearing. And remember, the 24th hearing was a very long hearing. It was so long that they needed a continuation to do a 2-day hearing for the 24th hearing. So his performance throughout the 24th hearing from day 1 into day 2 was absolutely consistent. If he were my personal client, I couldn't have been happier with his performance. So if you are concerned about his performance in court because you're wondering, was he unprepared? Would he have struggled? How would that appear? It appears that even though he did not realize this was coming, he had enough training to be able to answer this on his own. Not very much, maybe 5 minutes. I usually give people some time to settle in. So you haven't missed much at all. We're recovering the question about his unpreparedness because there was another question very similar that had to do with, because of that, did he perform well? Did it affect his performance? And the answer is no, it didn't affect his performance. His answers were consistent. Some of them were simple, some of them were slightly embarrassing to say out loud, but they were honest answers, which is again something that I would tell my clients to do, that every attorney would. We also tell them to not go unnecessarily into details when it's not necessary. We teach them not to lie. If you do not know something, you do not know something. However, if there's a possibility you might have known the answer at some point in time, because it's been long, you might have known that answer yesterday. Even you might know the answer of something before. For instance, I cannot find my keys. Where did I put my keys, Mom? I don't know. Where did you put it? I knew where my keys were at one point. I just don't know where my keys are now. So if I were in a courtroom and they asked me where the keys were, the correct answer is not, I think I left it in the bathroom. No, 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 no. You do not say you think you left it in the bathroom. You don't take a guess. You also don't say, I don't know, because you did know at one point where those keys were. What you say is, I do not remember, or I don't recall at this time. Because after you think through your memory brains and you spend some time searching in your purse, and in the purse you had maybe 2 days ago, and maybe in your client files, you figure out where it possibly could have been, and maybe it wasn't in the bathroom, maybe it was somewhere else. So you prepare your clients how to answer truthfully. So I do not know. I do not recall. At this time, I do not remember, are all legitimate answers. Other than those answers, the other answers he gave during his own testimony were excellent. He has managed to form holes in the prosecution's cases. Because remember, the prosecution has the burden of proof. They have to prove beyond a reasonable doubt each of the indictments. There's a total of 9. Out of the 9, he has contested 8, saying he's not guilty. For 1, he has pled guilty. It's the one where he said, yeah, I converted Korean won into casino chips. That's a violation, like a parking violation. Like when you jaywalk, if you live in some countries, you get violations if you trash on the street. Speeding tickets, it's a violation. I did that. So he pled guilty to 1. 8, he said not guilty to. And throughout the 2 days where he stood on trial, where he stood in that box and he replied to the court, to the prosecution, to the judge, to his own defense attorney, he made very good use of his time and was able to explain his side of the story while at the same time creating doubt. And that's his job, to tell his story and to show why his story is accurate, why there is doubt in the case against him. And he's done that. So I'm going to move on. In line with his performance, there's a question that was sent to me that's very similar. So I try to group questions together to save time and to help keep things in perspective. So give me a sec. Okay. This one was sent to me on Instagram. I wanted to know if what he said about his parents living next door, having the password to his house, and constantly surprise visiting him is a good defense against the accusations that prostitution happened in his house. So this person wants to know, was that a good defense? Does that make any sense in a court of law? Good news is it is actually a good defense. It's a very good defense. Now, in certain European countries, people might be slightly more taken aback to using that as a reason why you won't have prostitution taking place in your own house. But then again, in most Western countries, your parents probably don't live next door. You probably haven't given over your keys to them. But in South Korea, yeah, you often give grown adult men and women often give the keys to their apartments, houses, to their parents, sometimes their siblings. These parents and siblings can come and go as they please. Sometimes when their sons and daughters are at work, the moms will go in, refill their fridge with food, sometimes with groceries, sometimes with cooked meals packed in little lunch boxes. It happens all the time. So in South Korean context, as he says this, the court can actually imagine and picture their family members coming to visit them unannounced, and they will know what that means. So mamas always go to clean or cook. The cleaning part, I did not mention that, but so true. They also show up to clean. Yes, they come to clean your adult children's house. It's one of the nicest things about South Korean society. There's many things that are not always nice about it, but having that close family tie where even though you're super adult, you have people come into your house as they please. Dads do it a little less. It is a patriarchal society. However, dads show up too oftentimes. Dads show up to grab a beer or rather soju. To just ask their son if they want to hang out. Sisters come in, steal their brother's clothes, borrow equipment, gadgets. It happens all the time. those who follow me personally know that last year, it's been a while. Last year, during the height of the coronavirus in the US, I was gone for a couple of months. I was in the front lines. While I was gone, I left this phone, the one that has VLM on it, and that has also my personal Instagram on it, in the care of my own brother. My brother, being my brother, who, by the way, is also in a VLM. Uh, he's Mr. Our business legal expert. Trolled me. He went around telling everybody my life stories from the time I was born to the time I am now. He trolled me. So we of Asian background are not surprised when we come back home and we see that our brother took over our Instagram account. So saying that he is mentally aware that his family may enter at any given point, complete sense. That's why family always using his clothes. Yes, Pam, exactly why Ree's family is always using his clothes. Always. When my brother and I laugh about things, and when I compare him to kind of being kind of Riri like, Riri is also his bias. Yes, we are VIP family, a lawyer family, VIP family. He and I share that same kind of relationship that Ree and Ree's sister do, off almost in different ways. But yes, that exactly why Ree's family are always using his clothes. Go figure. But yeah, so that wasn't a bad defense. It was a very creative defense. It was also a genuine defense. It's one that South Koreans relate to. That not just South Koreans, that many of us with Asian backgrounds relate to this. My mom will never ever bother knocking on my door. She will walk straight on in. Why knock on doors? Let's walk on in. There are times when I have to be like, don't. I'm not decent. And sometimes the answer is, but it's just me, honey. And you're like, oh, mother. So, as Asians, as South Koreans, they pictured that. They pictured the fact that we are very conscious about the fact that our parents either live right next door for me, or for me, my parents live right outside my door. I live at home. My mom can literally walk in the door right now if she wanted to. She would not knock. There would be no knocking taking place. It would come right on in and say whatever she wanted to say, do whatever she wanted to do. Okay. Soyoung 언니, I see you there. 안녕하세요. We know why Hana has his clothes. Exactly. That's why Hana has his clothes, you guys. That's why Hana has his clothes. We can relate. Karen, hi, dear. Absolutely. Yes, we know, don't we, as Asians? But what with that, not like saying that the girl may lie about being in her house. Okay, there was also a bit in the article where there was no confirmation in one of the articles where we mentioned that there was no confirmation that this particular woman actually was at his house. He said he'd attempted to find out about it, but it never came back to him if it was or not. So that's another excellent point. There has been no specific confirmation that, yeah, it happened. So we're going to move past that question because we have some more questions. In the meantime, if you guys have questions related to what I'm saying or somewhat related, start typing it in so that I can, get to your questions. I'm going to turn around this way and see what my next question is. I've got two areas where questions are coming from: Instagram, Twitter, Instagram from both VLM, my own channel, and then Twitter, obviously, VLM. And while I'm reading, I'm going to sip water. Okay, there's a huge portion, a humongous comment that has to do with the article that I wrote for Business Mirror. I'm thinking I'm going to come back to that just a little bit later, so that I give myself enough time to do that. Let me see what else we have other than the Business Mirror. That one, gadget number 2 to check for questions. Uh, Okay, so here's one. This was recently sent, and this has to do with the fact of the casino chips that he pled guilty for. Okay, so they want to know, why did he plead guilty for the casino chips, basically. Why not just, plead not guilty for this as well? Because if he does plead guilty for this, and even if all the other 8 come back innocent, doesn't that mean people can say he's a criminal? So this person, that's what they're asking. So I'm not reading out the entire question, mainly because it's a little choppy with the English, but their question is related to, why not plead innocent for exchanging money into casino chips? Won't that affect him later if he's found innocent on everything else? Because he will still be guilty on this. They're correct in one sense. So we're going to first say how they're correct. They're correct because, yes, he has pled guilty to exchanging Korean won, which is money, into casino chips. Once you've pled guilty on that, that will not come back as an innocent verdict, because he's literally pled guilty. That's no longer an innocent verdict, is no longer an option. So you are correct about that. As to why would he do that? It's fairly simple, actually. There is evidence that he did it. He knows he did it. So with evidence being present and the fact that he has done it, it is the best course of action to simply say, yes, I went ahead and got casino chips, instead of trying to lie and say I'm innocent when he has done it. And there is a trail of evidence to see the casino chips did take place. While I do say this, I would like to point out that if at any point this community needs to talk about the casino chips, it's very important to mention the fact that changing money into casino chips is a violation. Different types of crimes or different types of things that are illegal have different ways. Violations are mere things that never include prison terms, meaning your freedom is never taken away from you. These are rather minor instances. Littering, jaywalking, traffic ticket, parking ticket. These type of things are all violations to get an idea of where this is. It is a violation. So when you go back, go armed with this. Yes, people may still keep pointing that out, but this is a violation. If you've ever gotten a speeding ticket, then you violated the law too. So these are violations. I see a couple of points, some comments about Asian families still. Yes, with no solid evidence from prosecutors, can prosecutors be charged in the sense of being unethical in their professionalism? Okay, so this is also very much related to some of the discussions we had earlier today on Instagram Live. Prosecutors themselves are a little bit harder to go after because they rely heavily upon the investigation that is done prior to the case arriving on their desks. And in this particular case, the prosecution, who is trying SR, in court are actually those who inherited this case from the civilian prosecutors. So the people who put the case together were the investigators. They then handed this over to Seoul prosecutors. Seoul prosecutors then reviewed the material and decided that despite the extreme weak case and rather lack of substantial material evidence. They had insufficient material evidence. This is a legal term. I'm using it one more time so you can remember this. Insufficient material evidence. They had insufficient material evidence. They did not have something that I would say is a very strong case, and they decided to proceed. So the decision was made by civilian prosecutors. They're the ones who tried the AWs twice. They're the ones who lost the AWs twice because the judge said, you don't have enough for me to grant you the right to detain an individual who you have not shown me any legal reasoning for why they have committed a crime, and there is no evidence there for me to take their freedom from them. So they lost the detention warrant twice, and then they decided to do something that is legal in South Korea, to indict without detention, because they could not, because they legally did not have enough to get a DW or an AW. They went ahead and indicted without it. This was the civilian prosecutors. They're the ones who made this decision. And then the reason this has gone to military court is actually more of a technical issue, because all of this was happening for such a long period of time. SR's age was also increasing. And in South Korea, there is a specific age by which you have to enlist. Enlistment is mandatory. And in order for him to cooperate with the case, SR had over and over again postponed his military enlistment. Now, you cannot just postpone this at will, meaning you can't be like, I'm going to postpone this because I don't want to. To postpone it, you have to send in a request to the military. And he did so. He did so not once, not twice, but 3 times. And according to the law, according to South Korean law, you can do that, and you can do that up to 3 times. How long of a postponement does it give you each time? So each postponement equals to 90 days. So the first time SR postponed for 90 days. Civilian prosecution kept on going with the case. They couldn't make any decisions. SR postponed it. Second time, 90 days. Investigators, prosecution still got on. AWs brought in, denied, still went on. He postponed a 3rd time, another 90 days. At the end of the 3rd 90-day period, he had run out of all legal options to postpone his military service. Let me repeat this one more time. At the end of his 3rd and last postponement, he had legally run out of reasons to not enlist. If at that point he failed to show up when he was summoned, then he would have committed a crime and he would have been in huge trouble. And it would have been considered, it would have at that point been considered as him attempting to escape military service. So at the end of his 3rd extension, the military manpower unit, the MMA, sent him a new summons. Now, depending on which article you're reading, you might see words like warrant being sent by the MMA. Bad translation. What they meant is the MMA sent him an enlistment summons. An enlistment summons means that your enlistment date is A, B, and C, or your period is between June 4th and July 4th, you need to show up between these 2 dates. That's what an enlistment summon is. It tells you exactly what your dates are, what your window is, when to show up, where to show up, and that you must enlist in that time frame. So it's an enlistment summons. Don't get caught up in the weird translations or some of the misinformation. So he went in. He went in not because he's attempting to not do his case, but because he's now obligated by South Korean law. He's obligated to enter. But what happens to his case? Well, South Korea had, at that point, its own laws. And I say at that point because today that law has changed a little. I'll explain that in a moment. But back then, South Korean law stated this: if there is an ongoing criminal case in civilian court and that individual must go in to serve because it is time, then that case gets transferred over to the military. That's what the law states. It gets transferred to the military. And in this particular case, the prosecutors and MMA both said that they would work together, that the military would respect the work done by the civilian prosecutors as they would take over the case and let the civilian prosecutors have their say in what they want. For instance, indict him on A, B, C, and D. The military said, we will cooperate with them. So if you're wondering about which prosecution has the liability, it becomes more complicated. Obviously, the military prosecution still has some liability. They will never be completely liability free since they took over, but the work was again inherited. There was also a guarantee and a promise that they would cooperate and they would follow the lead from the civilian prosecution. You see that that is still something that they're doing up to today, even after the trial began. How do you know they're doing that, even though they're not announcing it and flashing news articles? You know that because they've added indictments. You see, this last new indictment, the one with the aggravated assault, quote unquote gang violence, etc. That came straight out of civilian prosecution investigations, and through civilian prosecution investigations, they went after Mr. Y, and all of that was then given, transferred, cooperated with the military prosecutors, and thus they found new indictment to add, and they added that. So that actually came through the civilian prosecution. I see that you've got a question that's related to your first one, so I'm going to read that. So the change of event was good for him. That's now that the military prosecutors are not fully handled from civilian, which might be less biased. Yes, that is true. If his case actually did take place in civilian court, I would be a lot more nervous about what has taken place. Overall, military prosecutors are doing their job because, again, it is their job to represent the state and, in particular, to carry out the work that the civilian prosecutors have started. There's that agreement that already exists, so they are definitely doing their job. However, there wasn't an inherent bias to begin with on their part, and they have a little less reputation on the line than civilian prosecutors. Furthermore, what I think was perhaps the biggest advantage in this particular circumstance is it was a closed case. It was a close case. I know that VIPs might not find that to be an advantage, but take a step back. Having a closed case means this: there could not be a ton of random people showing up in the courtroom to stare at him as he testified for 24 hearings. Can you imagine if this was taking place in civilian court, how many people might be jam-packed in that courtroom? It could be a circus show in that courtroom. There could have been anti-fans in there. There could have been journalists. Remember the time there was 600 journalists? Well, all of them could have been packed into that room. So the closed court hearing was actually an advantage. One, because all of that media circus and all the fans or anti-fans or just normal public who all have an opinion about this case could not jam-pack that courtroom. It also meant that SR could focus on the case itself and not have to worry about other outside factors. It meant that the proceedings would not be disrupted unduly. The only thing that disrupted this particular one was coronavirus and some scheduling problems. So overall, things went a lot more smoothly at the military. Since I talked about advantages, it's also important that I also talk about the disadvantages that this included. Because in law, sometimes even if something is an advantage, there's something that is not so advantageous. There might be a disadvantage. So one of the disadvantages in this particular case was the fact that military prosecutors tend to be hard asses. I'm from America, so excuse my language. They're hard. They're hard. Military prosecutors are hard. And you see that in the fact that in their closing statement, instead of being lenient, they asked for 5 years. You clearly see that military prosecutors are tough. They take their job seriously. They don't give as much slack. So you could see that. So that was one of the disadvantage. Now, I don't want you to get afraid about that particular disadvantage, because I will then mention that just because a prosecutor asks for a certain number doesn't mean that's the number that we'll get. Last session, we talked about the fact that it's often also a bit of a strategy on the prosecution part. While they're being tough, they actually ask for more than they're willing to settle for. So if they think that 2 is the real number, they might ask for 4. If they think about 3 or 2 is something they will settle for, they might ask for 5. So they usually inflate a little bit what they're willing to settle. And what the defense does, in case there is ever a guilty verdict, is to look at what the sentencing comes down to. So let's say someone asks for 5, the judge dwindles it to 3, and then the defense is going to go and they're going to talk about sentencing, and they're going to reduce the 3 into a suspended sentence, where they're going to say, okay, let's take the 3 years, make it a 2-year suspended sentence, meaning for 2 years he's on probation. If he behaves well, if he doesn't do anything, if he shows that he's actually a good citizen and not a criminal and doesn't commit any crimes, then he has paid his debt to society. He has taken responsibility for himself, and he will be a free individual. Slate will be clean in 2 years. So there is always the beautiful suspended sentence as one of the main defense strategies. And that is a strategy that I believe would be extremely useful in the event that there might be 1 or 2 indictments that might have a guilty verdict. Now, just because there might be doesn't mean there will be, but it means there's a possibility. And we always need to keep in mind what is legally possible. Just because it's possible doesn't mean it'll happen, but we need to know. All right, so let's see here. There's a lot more in the comment section here, so I'm going to first read these comments. If there's a question that's in the same area, I'll answer that. Otherwise, I'm going to move to that particular big question that was over there and I was waiting for, because I'm getting closer to that area. Okay. Okay, so a lot of internal discussion as well, but I'm going to bring up a one particular comment, not a question, but a comment, because it's very important for all of us to hear that out loud. Some of you who will be watching this will be watching after it's been done live, and you won't know what I'm reading. So it's he brought receipt and proof. So by receipt, we're literally talking about he brought evidence. He brought evidence. He brought copies of documentation to prove his particular claims. For instance, when he said his family lived next door, he brought evidence that his family owns the house next door. When he said that people at the party weren't all just there as prostitutes, that this was an actual birthday party with people attending with their wives, their families, their girlfriends. He also brought evidence in the form of defense witness testimony. And you're saying, wait, what? Defense witness testimony? I never heard about a defense witness. Lack of media coverage that did not do a very good job of explaining it. If you look at my article, you will notice that I quite specifically point out that part of their evidence was statements from two individuals, and those statements are evidence. Those statements are testimonies. They're written testimonies. So the defense had two witness testimonies, maybe not a bunch, but their witness testimonies were very solid. They were there to prove that SR's claims of the party being a friends and family event was true to fact. And I don't know about you, but being an Asian individual, I don't think I would ever invite someone to a friends and family type event that would embarrass me in front of my acquaintances, in front of people who are there with their wives or husbands. So again, he is giving backups for his claims in forms of evidence. And while I had previously mentioned that the prosecution lacked convincing material evidence, that theirs was insufficient material evidence, in this case, those two witness statements taken in written form were testimonies, and those testimonies, as well as receipt, for instance, of his parents' house owning, those were very good material evidence, and those go to prove his particular point. So excellent over there. Comments about his parents were shaking. I would imagine so. I won't dwell much on that in this particular live, mainly because, again, I would like to stick to the legal facts. But yes, I would definitely imagine that his family is shaken by that. Shaken would be the least of what his family feels. They know what is at stake. What is at stake, in case some of you are watching, and many of you might also be young and baby VIPs, and some of you are not VIPs, some of you are curious, and some of you might be OT4s, and some of you might not be K-pop fans at all. So what is at stake in this particular hearing is this man's life, this man's freedom. How does he live the rest of his life? Will he be an individual who loses his freedom and has to serve a prison term? Or will he be an individual who does not lose his freedom ever? Not even for a week does he have to spend time in prison, because a prison term will change his life. So that's what's at stake. It has nothing to do with fan wars. It has nothing to do with if the man looks cute, what his body looks like, if he sings well. It has also nothing to do with if you like his music or if you despise his music, or if you think he's a good dancer or a bad dancer, he's a good fashion sense or a bad fashion sense. This case has nothing to do with those things. Instead, it has to do with, did he commit these crimes, and what happens to him? Does he lose his personal freedom and liberty? And does that change the rest of his life? Or does he keep his personal freedom and liberty and manage to rebuild his life anew, afresh, in the way that suits him, in the way that he feels comfortable? So I would really, really want to point out what the case is about, what is at stake. Has very little to do with any fandom wars that go out there. Absolutely nothing to do with those. I thought you would say no jury, but you're right. It's better. He won't feel the added pressure to perform. The reason why I didn't bring no jury up is actually quite simple. You might not know this, but in South Korean court, in South Korea's criminal court, that takes place in civilian life. So if you weren't, in military court, but civilian court, there would still be no jury. That's because it's customary for criminal cases to go to trial, and usually the defendants choose to do a trial by judge. There is a constitutional right for the defendant to choose what type of trial they want in a criminal case: trial by judge or trial by judge plus jury. It's not very often that defendants ask for a jury. It's extremely unpopular, extremely unpopular for a South Korean case to have a jury of their peers. They just don't seem to want a jury of their peers. Perhaps South Koreans know that South Korean community and public are extremely judgmental, and maybe that's why they opt out of the option of having a jury of their peers, because they don't necessarily trust that jury of their peers will follow the instruction of the judge and only make a verdict on the merits of a case. So that could be one of the reasons why, but very unpopular. Almost never will you see a jury trial, almost never. It might change in the future if people think that jury trials are advantageous to them. Okay. This is interesting. I see that it might have had an advantage, but the downside, it is prolonged. The length of it actually probably would have been almost the same in civilian court. It might have only been cut down by a few months. It took a few months during the transfer. So you only had a couple of short months during transfer that was added on. But other than ending a few months early, there wouldn't have still been too big of a time gap. The reason is this. There is always a 2 to 4 weeks gap that happens when these hearings take place, depending on if the defendant is in custody, meaning if you've lost your freedom and you're being held in a jail cell and being towed to your hearing. If that is the case, then your case is heard every 2 weeks. If you, however, are a defendant who has their freedom, meaning you are not being detained, and in SR's case, remember, no judge agreed to detain him. They were like, there is no evidence for us to detain him, meaning he would have been an individual who has a trial, a criminal trial, but he's not under detention. He's a free individual, which meant that it wouldn't have to happen every 2 weeks. There would be a 2 to 4 weeks gap each time. So it would have still taken longer. On top of that, the coronavirus would have still happened, and that would have still postponed hearings. And the shuttling of witnesses back and forth because others are now serving prison terms or have their own legal cases, or more coronavirus, all of that would have still happened. So yes, there would have been a slight difference by a couple of months, but I want to make sure we understand we're not talking about years of difference. We're talking about a few months, only the amount it took to transfer from one jurisdiction to the other. But the rest of the things that has happened would have happened there as well. So there's always weird things that people don't always know. He even said he would do the lie detector. I did not read that particular one, but here's one of the things that I would like to say. If you ever find yourself in any kind of circumstance where you want to use a lie detector, please don't use it. If you're in America, don't use it. If you're in South Korea, don't use it. I don't know what other reasons people have, except they think that it's going to show they're innocent. But lie detectors are notoriously wrong. The amount of innocent people who get caught with these lie detectors and end up being interrogated aggressively by prosecutors and detectives in the US and end up giving false statements is it's a little ridiculous, and it happens a lot. So if you ever found yourself in a situation where you're thinking, let me use a lie detector to show I'm not guilty, don't. Lie detectors detect the change in your body. That can happen if you have to go pee. I am perfectly innocent. I've never committed murder, but let's just say that I had the long day that I had today where I went to work early in the morning. I was awake all last night. I went to work early in the morning. I came home. I immediately sat down to do a live, and the live went on for 2 hours, and then I'm doing a lie detector. I haven't peed all day. That lie detector is going to find me guilty when I say I didn't commit murder, because my body is going haywire. It needs me to go use the restroom. Similarly, if I'm super cold, you'll notice that it's summer. I'm wearing long sleeves. I'm actually wearing a second layer. Earlier during the day, it was hot. I didn't need it, but it's evening now. The AC is blowing and it's a little chilly. So if I am super cold and the lie detector is going on at the same time, and that's affecting my mood, there will be a false reading on the lie detector. Lie detectors are notorious for not understanding what is happening with your physical body, your biology, and your physiology. So do not use lie detectors to get yourselves out of something, because who knows, you might need to go pee. It might be super cold in that room. All right, most realistic verdict we can expect. We've talked about much of that during my 2-hour previous live, so I would first refer anyone who wants to hear in more details about the various possibilities to find my personal IG channel. If you follow VLM Twitter, you can find me from there. If you follow VLM IG, you will also be able to find my personal channel from there. It's saved. It's 2 hours long today. I covered it in full detail. But if you want a quick version of it, I will go ahead and give that for you right now. There are 3 potential options. Option 1, he gets found not guilty on all 8, except for the one he did and he confessed to, which is the casino chips. Option 2, complete opposite of what I just said, where the other 8 are found guilty. Option 3, a mix and match, meaning he will be found innocent on some, guilty on the others. And it can be any variety of mixing and matching. And finding him guilty is not necessarily a completely bad outcome, because as I've also mentioned in my 2-hour live, that part of the defense's goal is, number one, if possible, all innocent on the first 8. But if that becomes impossible, our second goal, the one that we put a gold star on and consider a win, is when we fight for the freedom and liberty of our client and keep them from going to prison. So if we can keep SR out of prison, that equals to a win. So let's say there is a guilty verdict. It's not an automatic defect. That guilty verdict means now there is additional work for the defense to do. They need to go and reduce whatever the sentence is into a suspended sentence, where it's a probation. The person who's the defendant would never have to spend a single day in confinement, would never have to go to prison. That's considered a win. So that is the second best case scenario if it is impossible to go with all 8. So if you want the larger version, as I said, 2-hour live earlier today. Please go watch it. It's extremely detailed. There were so many questions that people were asking, so you might even find more information you're interested in. I'm going to go around to see if there's any specific questions, case related. There's a lot of internal discussions. I'm skipping over internal discussions. Of course, you guys are welcome for clarifying. Yes, it depends on small changes in psychology, and that can be triggered. Yes, so mainly, even if you get nervous, that will trigger it too. If your palms sweat, if you're giving speeches in class or presentations, you're probably not a good candidate for a lie detector. So very, very true. If you're anxious, yes, absolutely. All right. So I think I've seen most of this. Yes, thankfully his lawyer did not allow it. Now that we are done reading this part, okay, so let me answer yours, and then I'm going to go move on to the question that I've been waiting to answer. Aurora, so your question is also very much related to the questions we've covered in our first part of the live. There's a fine line in South Korea and in the United States between what is legal, what is illegal, meaning that line is super duper thin. Police in various legal jurisdictions, and not just the 2 I mentioned, in many other jurisdictions that I've personally practiced in as a human rights lawyer, have a very, very slim line. On one side of the line is deception, and police are legally allowed to use deception and some morally questionable means to interrogate suspects. On the other side of the line, that tiny thin line, is coercion. And the coercion is also where you have behaviors that are linked to that are all illegal. So that fine line. And until a fine line has been crossed, they can get away with the things they do. So your question would simply be answered by the fact that these particular police, at least up to what we know right now, there might be more that we don't know, and maybe it'll come out later. But from what we do know, it appears that they stayed inside that tiny, fine, thin line. They fell into what's legally allowed, morally questionable and ambiguous, but legally allowed to use deception. Um, just to give an idea of the type of deceptive things that they can do, I'm going to use a murder case just to use as something that you won't be personally attached to. So let's just say that you've been accused of murdering someone, and maybe you run with a gang. You're a teenager, you run with a gang, you've been accused of murdering someone. The police can literally lie to you and tell you that they have evidence against you. They can lie to you and tell you that your friends have all testified and said A, B, and C and pointed the fingers at you. The police can do these things. So, outright lying, even for a murder case, falls into that fine line of what is morally weird and probably not right, but deception is allowed. They can trick you, they can lie to you, and it falls into this legal spot. Coercion is something that is a whole lot more than that. So it's very unfortunate. It is, it doesn't mean it's right, which is why I keep on saying morally questionable. But there you have it. Okay, so the police had and then text people. They couldn't find anything. Police text people again without warrant. They went to his house. Yes, they've been after him for a very long time. Those who also have don't know me probably have never read my articles. If you follow VLM, go to VLM Twitter or VLM Instagram, you'll see that there are 2 news articles about the 24th hearing. Probably the only news article you'll find that actually has a legal analysis, meaning I literally talk to you about what South Korean laws allow, why things are taking place the way they are. So you might want to give those a read, and those do talk about something called confirmation bias. I've mentioned that. That means when you go into something thinking someone is a criminal, and your end result is doing anything and everything, finding every piece of evidence and interpreting that as, it's a lead that he's a criminal. Confirmation bias. So that's what you're mentioning here, Soyoung. They were so determined to catch this individual. So determined because of public interest, public pressure. We must do something to catch him. He must be guilty of something. They don't know what, but must be guilty of something. They turned every stone in his life because an individual might have some things buried in their life. For me, it's one speeding ticket that I had when I was in my early 20s. I was driving along, and it was a 55-mile-hour zone, and I was just fine. And then there was a traffic light. Right after that traffic light, the speed changed into 45. But I was young, I was carefree. I didn't notice that the speed limit changed. So there I was, still driving 55 in a 45 zone. Before I knew that, I get pulled over by a cop. And I was like, what's going on, officer? You're going 10 miles over. What? Why do I bring this up? Because if you dig with the intention of finding something wrong in a person's life, you're probably going to find it. If you intend to dig through mine, you're going to find that a speeding ticket that was super embarrassing. I can tell you that I am a lot more careful in my driving now. I don't ever speed to such an extent where you can actually find me, catch me, or anything close to that is probably always within that 1 to 2 marker. Point, you think someone is guilty, and you dig until you find it. You might find something. It might be something from their early 20s. It might be something from their teenage years, and they tried. They went as far as to look at his Halloween costumes. They were even interested to making sure that could he have broken any law when he was cosplaying in a cop outfit? Is there any possibility that he broke a law? Oh, so exciting. Let's go dig that. it didn't pan out because it was exactly that, a Halloween costume. No laws were broken. So confirmation bias has played a huge factor in this. All right. Let's see here. All right, so I think I see most of the questions answered on this side. Hold on to those new questions that might be coming up. I'm going to sip a little bit of water, and then I've got a huge question on here that I would like to answer. Give me a second while I drink some water. All right, so let me turn. Excuse me while I do that. And I'm actually going to read this entire thing out because it's huge and I might need to break it up to understand the question in parts. The first part is saying hi. I won't read that part. It's about my article. Okay. So the first part is just saying hi, and it's about my particular article. First, being that the prosecution decided they wanted to make an amendment to the 9th indictment for instigation into co-principals in violence, aggravated assault, and the judge agreed. Is this not unfair to the defense team, who deserve a fair opportunity to gather their own evidence so they can properly fight against this charge? Okay, so this is the first part of their question, and we're going to address that one before we move on to the second part of the question. So hold on. All right, so what do you guys know about what the original 9th indictment was? I tend to do a lot of my lives like a class because I'm also an educator in profession. So who here can tell me what you know about the original 9th indictment? What was it? Oh, someone said something. Oh, yes, that is me. I am the author of the Business Mirror article. I wear many hats. I wear many hats. So yes, I am that author. I am the lady with the JD, LLM, and whatever else they have listed there. Okay, so anyone can answer that. Incitement, treating violence. Okay, excellent. We've got an answer. That Seungri had his bodyguard scared and intimidate an individual. Also good. Okay, so both of these are correct answers. The original 9th indictment was about inciting the use of threat and violence. They also brought in the idea that it was gang related, etc., etc. During the trial, we obviously found out that we're talking about bodyguards. Also, that SR himself did not have any direct role in doing any such things. Okay, so it was incitement. Another word for incitement is instigating. So if you read my article, it has the word instigating. Instigating, incitement, all of those mean one thing. All of those mean that you're egging someone on. For instance, I don't know. Let's use the example of teenagers again. I'll randomly pick an example. Tom is hanging out with a group of friends, and Tom doesn't like someone else who goes to high school with him. They've been having arguments. So you instigate your buddies, or Tom instigates his buddies, to corner this other individual and bully them and get their lunch money. Tom himself doesn't do anything, but he instigates it. So his group of great friends corners poor Sam one day, takes his nerdy glasses off, bully him, get his lunch money. And that's an example of a high school intimidation tactic where there are actual people who did the offense, friends, and then there's the person who incited, who egged it on, who inspired it, maybe even planned it a little bit. But instigating. And I'm using a very simplistic example. Just please keep this in mind. I'm not using a very fine-tuned example. I'm using a very simple one so that laymen, meaning people who are not within the particular profession, can understand this and can follow it in a sense that you're familiar with. Everyone's familiar with high school bullies. So in that sense, this ninth indictment was then about instigating. Instigating is one type of crime, but it is all about, what would I say? It's measuring the level of, I'm trying to think what words I can use that are going to be user-friendly words. So give me a second while I attempt to find a very user-friendly English word that is not technical, because technical terms will probably just confuse everyone. I would say that if you think about it, complicity, how complicit. So complicity is a word that you can use in everyday language. Like, how complicit were you? It's a little bit tougher than everyday ordinary word, but I think complicity is a word that most people would understand. So it's really judging the level of complicity an individual had in a crime. So an instigator's level of complicity is higher than a bystander's, and a co-principal's level of complicity is higher than an instigator's. A co-principal is two words put together. Co meaning you are also. A principal is kind of like you have a principal shareholder, that type of a thing, a primary. So a primary person who committed the crime. So a co-principal is a word that is a legal term, and that is why I used it in my particular article. A lot of the articles that you've probably seen on Naver or other places probably didn't translate that correctly. A lot of places, if you look at Google Translate, I've seen things co-author. I've seen co-author in one of the Google Translates. So if you're seeing the word co-author, they actually are saying co-principal. That's what they're trying to say, is he's now no longer being indicted, no longer being charged as an instigator. Instead, he's being charged as a co-principal, someone with a higher level of complicity. The reason why I'm taking long to discuss this is because this is a major change. And this individual who asked me, is it not unfair, asks an extremely good question. Going from instigator to becoming a co-principal, someone who has a higher level of complicity and thereby higher responsibility to take for the commission of this act. An instigator, if found guilty, is not punished to the same level as the main person committing a crime. The person who's the main person committing a crime, a co-principal, on the other hand, is someone who's considered to have jointly committed that crime. They are then punished in the same way that the principal offender, that the main offender, is punished. So I'm going to repeat this again. Don't freak out. I will read any further comments that come from this. And keep in mind that there is a second question over there that I will later answer. But let me say this one more time. A co-principal is punished at the same level as the main principal offender. And it is a huge change that took place. And to say, is it not unfair that the judge agreed? Yes, I would say it is. That is one of the things that I was taken aback. There's many things that the judge has done that the community has not liked. And whether I liked them or not, a lot of those made a lot more sense to me. I could see it. This is one that I personally was taken aback because, and I was particularly taken aback because, and how do I say this? At the hearing, even the prosecution mentioned that there was a lack of evidence. There was no evidence that Seungri committed this crime. And yet they say there was complicity. There was an agreement. How did they come to this idea that there was an agreement between the two? Because a person stayed and waited? Yes, it's probably poor reporting, and it's probably pieces of the news that we don't have all the arguments for, but it took me by surprise, and not many things take me by surprise. I would say it was unfair. He did listen to both. So the judge did follow correct procedure. The judge listened to both sides, took all factors in. Having taken all factors in, he still went ahead and did this. Was it within the frame of the law? That's the second question that has to be asked. If you're asking about fairness, in tandem with fairness, we also need to know, is it within the law? Yes, it is within the law. And I'm going to explain that to you in a second. And it's not going to be very pretty. But before I go on to explain that, I'm going to read comments. So before I explain that part about being falling within the law, let me read. Okay. First thing first, very interesting. You used the word taken aback just like I did, which goes to show this was shocking. Yeah, taken aback. Okay, so what kind of possible legal framework is there that the judge could have used that even puts me in a situation where being experienced, I was taken aback. Well, unfortunately, there are legal precedents here. So I'm going to go ahead and start talking about these. So first, principle in this case is a legal term, meaning main, primary. So principals are, in legal terms, the primary people who have been charged with an alleged crime. Co-principals are then people who are co-defendants. They're both treated as the same, even though one is primary, the second is then a co-principal. So typically, if you're thinking about a crime, then you think of the main defendant as, that's the guy who did the crime, that's the one who's a criminal. And it often turns out like that if they're guilty. But there are actually some differences in types of principles. For instance, let me explain this if I can. In a principle, it's again a legal term, there is what you can define in degrees. Degrees judge how much of liability, responsibility, and complicity these individuals have. The higher the level is one, and the lower level is another. So there are two levels, first degree and second degree. Okay, so now let me explain to you how it is for a first degree. So a first degree principle is a person who's been charged with actively carrying out crimes or criminal actions. For instance, they did it themselves. They took out a knife and stabbed someone themselves. They themselves broke into somebody's car and stole it. They themselves committed the crime. That is the first type of principle. They have the higher level of complicity, of responsibility, of liability. There's a different type of principle that has a lower degree, second degree. And this person is a person who's present during the commission of a crime, who might have not participated at all. This person is present during the commission of a crime, but might not have lifted a single finger to do anything at all. Is it starting to sound a little bit like what this particular SR case is about? For instance, the prosecutor has admitted SR has not lifted a finger to commit the particular crime. It does not exist. So the prosecutors are viewing him as a second degree principal, in this case, second degree co-principal, present during a criminal action. But then you're like, wait, just by being present, is that a criminal offense? It goes one step further. In labeling someone as a second degree, you also are implying and alleging that even though they were present and they did not actively participate, they didn't break the door, they didn't hand him a weapon, they didn't stab anyone, even though they did not actively present, they knowingly were present to help or support the commission of the crime. They were knowingly present. Again, if you read the prosecution's statement, the prosecution has made the argument that based on what they heard from Mr. Yu, SR had decided to hang out and wait with Mr. Yu, apparently, and the very act of waiting, they have defined it and interpreted that as knowingly agreeing to whatever was about to happen. These are typically passive roles in law. For example, let me give you an example of a real second degree case. First, I mentioned someone who might have broken into a car. Well, let's say there is now an armed robbery taking place. There are first degree principal who's actually conducting the armed robbery. They've got the gun. They're holding people up. But then there's someone else who's waiting for them out in the alley. They've got a getaway car. This person is not committing a single crime. They're just waiting with a car. Or another example, there is someone else also present during the commission of the crime, and this person doesn't even wait for a car, so you cannot even try to say he's someone who assisted them after the fact. This person is simply standing on the corner of the street. What is this person doing? This person is a lookout. The lookout has not committed any crime, is not even going to help the person get away after the crime. Remember, helping someone get away after the crime can later on make you an accessory after the fact. So this lookout is not even an accessory after the fact. However, this lookout is standing there being a lookout as the crime is being committed. And if this person knowingly standing there as a lookout, knowing that someone is about to pull a weapon out and commit armed robbery, they can be then charged as a second-degree principal. So this is the legal basis that the prosecution used to up the charges to co-principal. This is also the legal basis that the judge took into consideration when accepting the change. The judge listened to the fact that there is a way to interpret SR's action as, okay, yeah, I'll wait, as in, okay, I'll be the lookout, in the same manner. Now, you don't have to agree with it. I personally, as I said, was taken aback because I didn't necessarily think it was the correct interpretation, but the judge has allowed it. Now, in tandem with saying, was it unfair? Why did the judge allow it? Was there a legal basis? There is one last question that has to be attached to this. And this is also in that first question that this person asked. Let me read it out. It's about the defense, who deserves a fair opportunity to gather their own evidence so that they can properly fight against this charge. It was related to that, the fairness. The defense has chosen to respond to this particular charge in South Korea using South Korean law that says they can submit their case, their testimony, their defense in writing. That's what they chose to do. I have noticed one thing about SR's defense, whether you like it or not. SR's defense likes to make use of the written statements as means of testimony whenever it is possible, in particularly in cases where he's surprised, in cases where it is hard to reach witnesses, for instance, in different countries. He has gone to option 2 in those cases. I did stop and ask myself, if I were in his defense's shoe, would I have opted to go for a written testimony, a written statement, argument against this? Or would I have asked for additional time? And that was a question he probably asked himself. Do I ask for additional time? Or do I do this outside of the courtroom? Do I write up however many pages I need to and submit it? The written statement has the same legal bearing. It has the same weight as if he said those words out loud in court. And even if he said things out loud in court, remember, as I mentioned, you usually get the Cliff Note version. If you're not in America, you don't know what Cliff Notes are. Cliff Notes are... they're little books that give you brief summaries of other important things, like Cliff Notes version of The Tale of Two Cities by Charles Dickinson will dwindle down a 500-page novel into a short 10-page informational guide. So Cliff Notes are dwindling down pages of things. So in court, when SR's lawyer speaks, he's actually giving summaries of his main arguments, and the rest are always in his huge presentation of files that are filled with paperwork. As I've said, sometimes they can be up to 100 of pages, but 40, 60, very, very usual to see that. I've seen it go up to hundreds. So SR's lawyer probably considered the fact that if I did this, if I asked for a postponement, I would be writing something up anyways. I'm going to be writing this up anyways. Then I would have to present just a part of it, and SR would have to then get stuck answering questions all over again. not just what was answered today, but one more time, pros and cons. He decided that he didn't want to take the risk of putting SR in the position of having to answer things all over again. He probably also felt that since they were close to closing, it would be in the defense's advantage to go ahead and close now instead of trying to hash this out and not knowing where this could go if he hashed it out in open court where you can go back and forth with cross-examination. Don't forget, if he takes this and does another hearing, this will then become a cross-examination and go back and forth. Do I do that? Do I take the time? I think after weighing all of that, he decided the best option is, since we're close to closing, he's already answered this. Let me then take the rest of it. Let me do what I can do legally by South Korean law, which is present my entire case through my papers, written statements, written testimonies, written evidence, anything else that I need. So hopefully that answered all the block of question that is related to this. I'm going to again take one moment and read the multiples of comments that are here to see what everyone thinks. And while I'm reading, I will also probably take a water break before I do the next question, because I still have another major question over here. If you guys have questions, I will also get to yours. If your questions are shorter, I might do yours first, and then I'll go to the long one. Okay, so, but does that mean the judge agrees that at some point there was a silent agreement? How do I explain this? When a judge agrees to change a motion, as in to let the indictment change from being something slightly lower instigation to slightly higher, it doesn't mean that he thinks that SR is guilty. That's not what it means. It means that he understands the legal reasoning of the prosecution, and he agrees that the prosecution has a legal basis to make that request. So it's hard to separate him, at least for everyday individuals, hard to separate the fact that he's not agreeing to SR being guilty or having made a silent agreement, but rather that it could have happened that. And if it did happen that way, then the prosecution has a legal basis. He's acknowledging the possibility that it could have happened, and if it did, the prosecution has a case, and he wants the prosecution to go hash it out. So then he will know, do I believe it now or do I not? So it means he's giving them the chance to pursue that angle, to see, did that happen? Did that not happen? It is still something that was extremely surprising to me, because as like I said, I would not have interpreted this particular situation in the way the prosecution did. It's very hard to interpret it that way. But as I walked you through it, you saw how the prosecution did this. I'm not going to do this because I'm against Riri, or I'm a glutton for punishment for myself with the hate messages that will come to my DM. But legally speaking, I think this was a really brilliant move on the prosecutor's part. So yes, I just complimented the prosecutor. All of these times, the prosecution has not been able to do anything that was, I would say, worthy of mention. They've been floundering, literally floundering. All of the prosecution's witnesses turned out to give testimony in favor of Seungri. So all of this time, the prosecution has looked like fools until right now, when they were able to make an argument that was unusual, extraordinary, and yet perfectly legal. So as a legal analysis, that is something worthy to note. doesn't mean I approve of it. Please understand, this does not mean I approve of it. But if you're asking for my legal commentary, then this would be their one good move. All of their other moves made them look like fools, but this move makes them look like out of the box thinking lawyers. Okay, let's move on. Came at the perfect time. Thank you for explaining principles and precedents. I don't have enough framework on these in the US, but especially in SK, I'm really glad that you caught it at the correct time. So it may seem as the lookout for someone stealing a car, for example, exactly someone who's completely passive, has not done anything, not even the guy who's driving the car away, but look at, he's just standing on the side of the street. And that is how the prosecution has framed this, and that is the argument that the prosecution is making. And it's going to be the defense's job. I mentioned that they will be submitting their defense in written statement, hopefully many pages of it, just enough that it is complete, but not too much that it puts people to sleep. But there should be several pages that are typed up that tell us why this is incorrect reasoning, where the flaw in the logic is, where the flaw in the evidence is, discussing the burden of proof, poking holes into that precedent, etc. There should be several pages of it. Excuse me. It's been a long day, you guys. And my body is reacting to the fact that I haven't slept in 4 days. For those who are wondering why, it's because I also rode the 2 BM mirrors. I went to work every day at 6 a.m. I came back home. I typed articles until 4 a.m. Then I went to work again at 6 a.m. for 4 days in a row. So my body is not reacting very well at this point in time. That's what happens when you don't take care of yourself. Your body rebels against you and tells you, Saba, you're a human being, go take care of yourself. How do you prove a silent agreement? You just have brilliant questions, don't you, young lady? Okay, how do you prove a silent agreement? That's a good question. That's something that it's up to the prosecution. The burden of proof is on them. We obviously have not heard the full extent of their arguments, nor have we read everything that they have typed up. What their job is going to be is to show actions, gestures, try to draw inferences from body gestures, anything and everything that Mr. Yu said that they can use. And it won't be very hard because Mr. Yu's probably given a statement that has said that he agreed to stay with me, or he knew I called people. So it won't be very hard. But just because it won't be very hard to be able to draw some of these conclusions does not mean that they will be able to prove it beyond a reasonable doubt. So drawing a conclusion is not equal to making that conclusion beyond a reasonable doubt, proving that beyond a reasonable doubt. So even though they had enough to be able to draw that conclusion, proving it will probably take more. And that's where SR's defense is so important. Hopefully, like I said, there's several pages of this where what he'll do, and this is one of the advantages to going second all the time, and the defense always goes second. So what he'll do is he'll have the papers. I just wish I had brought a book with me, but I don't. We're just going to use my tiny little notepad. So here we go. So here papers, yeah. So he's going to have this one. Let's say this is the prosecution's papers that clearly define their case, all of their arguments. They're going to read over it. My one says 1, 2, and annotated on the sides. They annotate. Annotation is one of the best things that a lawyer can do because it saves us so much time later. We annotate a lot. Well, maybe not everybody, so I shouldn't say in general, but many of us do, because it definitely helps us put our thoughts together. So he'll probably have a copy that he can annotate, and then he's going to start making arguments against. Point 1, counter argument. Point 2, counter argument. Counter argument followed by evidence to support my own argument. Point 3, counter argument. Here's a legal precedent to support my stance. So every argument followed by a counter argument backed by either evidence, by precedents, and one by one, he will go through every single thing that he got from the prosecution, he'll include in his. So that is one of the advantages of going second. He'll go through this thing as if he's a PhD student getting ready to defend his thesis. The best part is, unlike a PhD student defending his thesis who's half sleep deprived or any other kind of students going through examination, he has a legal team. And his legal team is going through and doing the same thing with him. He's got people researching the precedents, finding them out, talking it over with each other, how they can be applied. He's got people who are brainstorming ideas of what kind of evidence he can use and how. He's got people who are there to help type up portions of it for him, if not all of it for him. Give me a second. Guys, I typed in a question. I asked if we're still connected. Can you tell me if you see that? Okay, I'm seeing questions. So I'm assuming this means we're still connected. The reason why I say that is because my YouTube is giving me something weird. Okay, so the connection went out and it's back again. Don't ask me what's going on, but in case the connection goes out, someone who is on my Instagram with me, IG me and let me know, because maybe there's a storm. Actually, there was a storm earlier, so that could be affecting signal. So in case I go out, one of you people on my IG, DM me. I will check on this if I see it looks frozen. So I think that really explains, hopefully, some of the questions that you had. I'm going to go and try to see if I missed any other questions. So what's stopping the prosecution from using this in all of the other charges? One thing. There is nobody that is saying that SR waited with them. For instance, Mr. Yu has never said that SR was in any way linked to his own criminal activity with prostitution. The prostitutes who did get brought for Mr. Yu's case also didn't. The women who were brought in as witnesses on SR's case did not even imply, they didn't even know he existed, some of them. So they actually didn't have a sliver to even make him the guy standing on the side of the street. They didn't even have that on some of these other things. On embezzlement, etc., they do have something, which is why he's charged specifically with embezzlement. But on some of these other things, they really were lacking, as I said. Insufficient material evidence, not even enough to do what they did over here. I actually agree with you on the prosecutors. I'm surprised they didn't start with this angle. Well, you know what? It's been a long several years at this point. I have lost track of the entire time, because my days and nights all blend together. I go to my work, I come back home, I do VLM. If I'm doing VLM and I have to write an article, I do VLM, I write an article, I go back to work. And my days and nights and year has all bled into one big thing, and it feels like it's existed forever. So I understand VIP's feelings. So I completely understand VIP's feelings. I don't mind at all that sometimes we use our emotions and we're upset with things. Of course we are. Our lives have blended into a one big blob, at which that sometimes I forget what day of the week it is. So one big blob. And I can say that of some of the VLM's other members as well, because they too are staying up all night taking care of things, and some of you guys do too. Okay. Is Mr. Yu the same person who refused to give a testimony? I also want to ask, is it normal in SK that a person can refuse to give one, unlike in other countries, for example, America? All right. Yes. Mr. Yu is the individual who refused to come to court. Mr. Yu did come to court for the prostitution and prostitution mediation part earlier. However, and again, I just wish media would be very clear when they talk about this. He was summoned a second time for the new one, and he said no. Is it possible legally for him to deny to testify? It's a yes and no. Yes, meaning he can ask to postpone. Yes, meaning he can ask that I cannot come to court. No, meaning you cannot get away with not testifying. So what the man actually did was present written testimony. So it isn't that he didn't testify, the man testified. The prosecution used the man's testimony to up the indictment. The man testified in written form, and the written testimony. Oh my goodness. Water break. Sorry about that. Those of you who follow me know that I suffer from constant dry throat when you work as a lawyer and as an educator. All you do is speak. So my voice has issues. And yeah, sorry about the coughing break, the water coughing break. Where was I going? I was talking about yes and no. That's right. So here's what happens in SK, South Korea. There are specific rules that state when a witness is allowed to skip in-person testimony, and if those legal parameters are met, and there is no option for them to come in, then the court can grant them permission to do a written testimony, just kind of like SR's um, people from Japan. They submitted a written testimony that was submitted as evidence by the defense. Similarly, Mr. Yu submitted a written testimony which was submitted as prosecution's evidence. Um, there was a possibility for the court to reject him doing a written one and demanding he come in person. There was a way that they could have done that. But the reason that they didn't is because Mr. Yu is currently facing his own case with this particular charge. And this case is one that can affect his personal freedom, meaning is he someone who will be free? Will he get incarcerated when liberty of another person is at stake and they have their own case to prepare for? The judge will give the person who has their case priority to handle their own case. So so if this is true, even if we're talking about a guy named Tom and a guy named Sam, Tom and Sam both have hearings. Sam's hearing is going on right now, and Sam needs Tom to come and give a testimony. But Tom has a case that's about to start where his life changes drastically. His freedom can get taken away. He might get put into prison. Legally speaking, Tom has his personal right to prepare for his case takes precedence over him having to show up in court, which is what happened. That took precedence. He got the judge to agree. There was another route that could have happened. The judge could have agreed to let him skip it and come back later when he was free. Okay? But when he was free has a big downside to it. His case on this was getting started. If you watched how long cases take, by now most of you have noticed how long cases take. Cases take an average of this long, sometimes a little bit less, sometimes a little bit long, but they take a long time, you guys. If the judge would have been like, you know what, I excuse you for right now, come back after you're done, you could be waiting until next time this year. I mean, next year this time. Ooh, yes, it's been a long several days. You can be waiting until next year this time for that man's case to be over before he's free to give testimony, where his own right to defend himself is no longer in conflict. So if the judge had been persistent that you show up no matter what, we will grant you your right, but you come after, that would have meant prolonging this thing for months, several months, or if you're unlucky, even a year. And that would not have been logical, and it would have been technically problematic because SR is slated to come out of enlistment this year very soon. Which is also why, if you have to know, that SR's defense lawyer agreed to this, because this was agreed upon by both sides. Both the prosecution and the defense had to be in agreement before the judge decided, and both sides were in agreement that, okay, let's have that written statement and get on with it. That's what they basically said. He's got to testify. Let's get that written statement. Let's get on with this thing. We've done this long enough. Let's move on. Let's get this done in the time allotted to us before it's time for the individual to be discharged. So that helps. You skipped my question. I skipped a question. Was it when there was a connection issue? Let me go back up. Was it Pam? Was it when we lost connection? Here, do me a favor. Retype that. It could have been when we lost connection because I don't see question. And while Pam retypes the question that apparently got lost while we lost connection for a minute, I'm going to see what else is there. Yes, he did give a written one, just not in person. How do you contradict a written testimony? I mean, how would the prosecution in this case could have said anything about that? Okay, how do you contradict a written testimony? I mean, how could the prosecution in this case could have said anything about that? You do it the same way as you would do for the ninth indictment that has now become co-principal. You go through, read every point that the prosecution has typed up. And again, remember the prosecution has typed up, there's let's say 2 pages, just for easy example. You're going to go through 2 pages. You're going to mark everything on there that's problematic. You're going to send your minions off to go research evidence, precedent. Then you're going to meet back and you're going to do one rebuttal. Here's why, here's evidence, here's precedent. So you're going to do it exactly the same way as I mentioned you would do for the co-principal charge. You would do the same thing with this particular one. You would do the same thing with the witness statement as well. So you have the witness statement, and then you have what the prosecution said using the witness statement. So you're going to go through the witness statement, and you're going to go through part by part, highlight the things you want to contradict, write the contradiction, why you're contradicting, your legal reasoning, the evidence, the precedents, one by one. The only difference is you're not arguing it out loud. But having said all of this, there is one other major difference that is different, which is cross-exam is not happening in person. So I'm going to keep drinking water because otherwise I'm going to have another coughing event, dry throat issues. Also, I realized that I've been talking since 11:30. It's been 2 hours. That might also explain why my throat is so dry. 2 hours of talking. And I did 2 hours around 7:30 earlier today. So 4 hours of legal lives and ongoing. Here we go. All right. So as I was saying, that there is still one major difference, which is that you don't have that in-person interaction. That in-person interaction of putting Mr. Yu in the witness stand and having him say it and contradicting him, that part is missing. That part is important, but that part can still, as I said, be done in writing. It doesn't have the effect of theater. I use the word theater because what you see in the courtroom is theater. You've already presented everything else in writing, but you're still going to court. It is theater. So it lacks that effect of theater in a sense. So I definitely will mention that. But despite that lack of theater, everything else that is tangible and important can be done in writing. So hopefully that answers the question. There's one other thing that I would say that's connected to it. Is that the best case scenario? Is that what you want to always happen? Of course not. Which is why the first thing you always want is to have your witnesses present things in person. But this serves as an alternative. Just like, again, I would point out that in the early days, the second hearing, I think the first, second hearing, one of those two, uh, it was either the first or the second, the court decided to allow the defense to present their witness statements in written form. So you see it happening on both sides at this point. So while both of these are not best case scenarios, both of those are compromises that was agreed upon by all three parties, and the prosecution has used it and the defense has used it. So we can keep that much in mind, that both sides have used this particular technique and both sides have agreed to each instance of when it was used, because if one party didn't, then the judge could not have unilaterally made that decision. They needed to have been in agreement. Okay, there's something else. No, I mean, if the prosecution can contradict again the written testimonies of the defense for the last charge, um, no, that's actually something that doesn't happen. What you're talking about is counter cross. So, cross, okay, there is, ooh, the prosecution asks person A questions and then they go away. Defense asks person A questions. Defense is now doing counter. Counter in this case is cross-examination. Now, if prosecution comes back and again asks a question, then you're really talking about cross-examination. And that is something that doesn't really happen with written testimonies. So whatever SR's people decide to say in the written document doesn't get a counter argument to it. So the prosecution's indictment is the main argument. The defense does their counter argument. There is argument and counter argument. You don't have a counter in this case. So that's what you're asking. Yes, the prosecution does not have the ability to counter the counter argument. They cannot come back in with that cross examination. I'm sorry, Saba, take care of your throat. I'm actually going to drink water because I have one last big question to answer. And I have one more water bottle in my room. I keep at least 2 water bottles with me at all times because I know I have this issue. Okay, the second humongous question over here. I'm going to again attempt to read this in its entirety so that we can break it down into what it's really saying. Second question I have is more general, legal one. What is exactly charge stacking? Okay, so I'm going to let some of you guys try this for a moment as I rest my voice and I let my students do this. Anyone here who has, yes, that's what I want. Okay, I'm glad I was able to answer what you needed. Whether you like it or not, I'm really glad I was able to give you the answers you seek so that you may make your own judgments in this, because that's what I'm here for, to give you answers so you can formulate your own judgments. Okay, so who knows what is charge stacking and when have you heard me speak of it? If anyone has heard me speak of charge stacking, would you like to have a try at these? It's very simple. In reality, it's actually pretty simple. Um, think about the word charge and think about the word stacking. Charge definitely means when you're indicting someone. Stacking is when you're piling it on. So if I were to give this a super easy answer, uh, I would say charge stacking equals to piling on charges. Um, and that is the easiest way to break it down. So there are 9 charges, so they're using that as a reason for the punishment. It's not 1 or 2, it comes to 9. So the number 9 here is important, not because it represents the number of indictments that have been piled on, so stacked on. They had maybe 1 or 2 to begin on, and then they stacked another charge on top of it, and then stacked another one, and then they stacked another one. They're piling it on. Think about Jenga or any other game where you're like stacking books or blocks one on top of another. You're just stacking it and stacking it and stacking it until we have 9 total. So you're piling it on. Why do we use the word charge stacking? Because it's actually a real technique. It's one of those things where I mentioned that criminal justice system is sometimes just unfair, and they use some morally ambiguous things that they do, and it's all legal. So charge stacking is all legal. It is a completely legal process and technique that are used, and it's used very frequently by usually investigators and by prosecutors. The idea is simply this: you overload something when you keep stacking things one on top of another. In a game of Jenga, when you keep on putting your blocks up, there's a chance that the higher this thing gets, it's going to fall all down because you're overloading it. Similarly, stacking a charge is a strategy to overload the defense with the number of indictments that they're so overloaded, it becomes a burden. They're literally trying to create a heavy burden on the defense. If the defense is burdened, it creates an advantage for the prosecution. The prosecution can be slightly more carefree because the defense has now so many charges stacked up, their attention is divided. They don't just focus on 1 or 2 related, like prostitution and prostitution mediation, or even 2 where there was embezzlements and prostitutions that were different, but you could group them. But now there's 1 here, 1 there. You are overwhelmed and burdened. And that is a strategy to purposefully create burden on the defense, giving an advantage to the prosecution and making it more likely that out of 9 indictments that the prosecution can at least get 2 guilty verdicts, 1 or 2 guilty verdicts out of this. The more things I have stacked on, the more work the defense has to do, and they're floundering their burden. Chances are I would be able to at least get a couple of guilty verdicts out of this with more of these stacked on top than if I only had 2. If they only charged him with prostitution, they might not have gotten anything. It could have been all or nothing if there was only 1 charge against him. Prostitution mediation, it was all or nothing. You're either guilty or you're not guilty on 1. Done deal. If it was 2, you got 2 and you still don't know which one it could be. But with 9, having created this burden, the prosecution has now created an advantage where the other people are burdened, and the other people now have to prepare themselves for the various possibilities where there is mixed verdict, where some might be innocent while others might be guilty. And with so much going on, the prosecution is happily letting this strategy go into effect. Um, I knew they were doing this the moment they kept on piling up charges upon charges. I knew immediately that this is what they were doing because it happens all the time. It is completely common practice. No one talks about it in the media that much. But if you go to law school, if you read legal articles, if you read perhaps legal newspapers, um, anyone who covers real court cases, I'm not talking about entertainment news that pretends to cover court cases, but people who are journalists who cover crime court cases, court journalists, you might see the word there. So it does exist, just not out there for everybody who isn't in the specific area looking at these things. But chart stocking is a real thing. The person who wrote this question isn't here at the moment, so I'm going to ask those of you who are. Does that help define chart stacking in a plain, easy to understand way for someone who's not from the legal field, someone who's a layman? Does that answer it in a way that's easy to comprehend? Please let me know. I try to use, again, as I say, I try to use simple examples that anyone can hear, relate to, because you don't want to use legal mumbo jumbo. You don't want to use jargon. Jargon is not helpful. Jargon confuses people, and that's not what we're here for. I'm here and I'm following. Interesting. We've got multiple people who had similar questions, but yes, I know you had that question. Okay, so you're here, you're following. That's excellent. Okay, so let me see if I've missed any other humongous questions. If not, then you guys get the next opportunity to ask questions. So those of you who are still here, please type up anything that I haven't covered yet. Okay, I'm looking at some questions that we've already answered, so I'm not going to touch base on ones we've already answered, especially ones we've covered in the first Legal Live. So I'm going to skip those if you don't mind. Okay, there is one over here, and I will go ahead and take the opportunity to talk about this. Again, this goes back to really the goals of the defense. I mentioned the fact that there is the two best case scenarios, one with being 8 non-guilty, one being if there is a guilty, your main focus goal throughout this entire case is to make sure the individual doesn't lose their personal freedom, is never confined. So this question is, how does this work? It's pretty simple. It's basically what I just said. If there is a guilty verdict, if there's one single guilty verdict, I'll use one as an example, then your job is to take that one and break down all the reasons why the sentencing on that should be suspended. In case of SR, For instance, if we talk about, say, embezzlement, you can argue that there was a lack of intent. He never intended to. He showed some receipt where he even paid money. Um, in terms of intent, you can also show that he used money in good faith, uh, and did not have the element of the crime that's necessary to meet the burden of proof. So if there is one element that is missing, such as intent, then that should be good enough reason that even if you do find someone guilty, that you realize that, there are possibilities that someone can commit embezzlement, one, without knowing it's embezzlement, and it's without having intent. And in case you're wondering, wait, they can commit embezzlement without knowing it's embezzlement? They can, because embezzlement is a very vague law. Even in America, it's not defined absolutely. If you happen to misuse your business credit card at dinner and you're, out to dinner with your buddies, but you use your business credit card, and someone wants to take you to court, they can take you to court for embezzling your company. Now, you obviously weren't intending to commit embezzlement, but they can do that, which is, again, why intent is so important. So even if they find that you might have actually done something that's not lawful, but one, you didn't realize that was not lawful because you don't know all the rules, and there isn't exactly a handbook that defines every instance of embezzlement. There actually isn't a handbook that defines there's only 100 types of embezzlement and nothing outside this is embezzlement. That doesn't exist. So there might be cases where the intent is missing, and in those cases, either there should be a return of a not guilty, but if that doesn't happen, then that is absolute reason to take the sentence and to make it into one where it's suspended, because they never wanted to commit a crime. In terms of SR and embezzlement, it's very clear that in either of these instances, there was absolutely no intention. So I'm hoping that that explained the how can this happen. All right. I'm taking last questions because I'm coming upon 2 a.m. and I started at 11:30 p.m., meaning it's going to be 2 a.m. in the morning. So last questions. Now is your chance. Okay, I think so. It's hard to look up stuff too because of what you said about media. They're not always educated readers and writers. Yes, that is correct. All right, guys, if you don't have questions, type in a big fat no down there. Someone give me a no. And while you're doing that, I'm going to do one last check on my end too to make sure I'm not missing something. There is one small question. I'm going to go ahead and answer this out loud. Someone says, when will the next trial be held? Let's use the correct terms first. When you're talking about trial, there's only one trial. This is SR's trial that's taking place right now, but you're talking about when will the next trial date be held. Trial dates can also be called hearings. We don't know. To be absolutely clear, we do not know because no one has reported it, and we don't know if that's because no one has announced it or they just didn't report. So we don't know. Will there be an actual date at court? From what I gather, the closing arguments have been made. A verdict is something that's left. Once a verdict is decided, if it is not guilty on all counts, then it's basically done. However, if we do not come back with a not guilty on 8, if that happens, if we go on to option number 2 in my slides on Instagram, Instagram's VLM channel, if it goes to slide number 2, then there will be the next hearing, and that hearing would be the sentencing hearing. So it really depends on what happens with the verdict. The verdict, once it comes out, if it is all not guilty, then it's a done deal. But if there is any guilty verdicts beyond the casino chips, guys, beyond the casino chips on the other 8, if there is, then there will more than likely be a sentencing hearing. Now, the sentencing hearing might not be a public one. The sentencing hearing might be a private event that gets done behind closed doors. You might not hear about it as well. But given the fact that this is a high-profile case, I believe that even if they don't tell you ahead of time, they will release the results after. So even if you don't know ahead of time, there's, a sentencing hearing taking place on day 4. At the end of that, they will release the results. So again, I'm going to ask, this person isn't here. Does that cover that question fully in your estimation? Pam, you are correct. If there is another one, it will be sentencing. Very well done. And I need to know from one of you wonderful people if I explained if and when a new hearing will take place. And under what circumstances there might not be any need for one. There is also probably a time lag between when someone types and when I read them, given the fact that internets everywhere are iffy and we live in a global society. So many of you live in different countries and jurisdictions. No, I get confused. Uh-oh. Okay, let's break it down. Good thing I asked, yeah? Let's break it down. So, what we're waiting on for right now is a verdict. We're going to do 2 scenarios. Scenario number 1. And this is a scenario in which the defendant is found not guilty on all indictments, which is 8 that he has pled not guilty for, because he's pled not guilty on 8. The other one is a fine. Okay, so the one with the casino chip is a fine. So that one's guilty. All other 8, he has pled not guilty. And let's say the verdict comes out and it's not guilty on all of those 8. Then there is no sentencing hearing, because what are they going to sentence? He's innocent. He goes home. He's done. He's free. If he's not guilty on all 8, there is absolutely no need for another hearing. So he goes home. Let's look at the other option. Well, obviously there's 2 other scenarios. One, which is the worst case, where you come back with, again, guilty, but it's all guilty. But I don't think you will get such a scenario, but just mentioning that there is worst case. But let's talk about the more possible likelihood, the center one, the one that I've been talking about, where there might be a mixture. And if there is a mixture where you got a mixture of guilties and not guilties, then yes, you will have to have sentencing. Also, obviously, if you have guilty on everything, you still have a sentencing hearing. So the other two outcomes of the verdict, which is a mixed guilt and mixed innocence or all guilt, requires a sentencing. What are you sentencing? You're sentencing a punishment. You're deciding, okay, he's innocent on A, he doesn't need to be punished, but he's guilty of B. What should his punishment be? Or if it's all guilty, then he's innocent, he's guilty on A and B. What should his punishment be for A? What should his punishment be for B? How do I combine these into punishment together? So, sentencing hearing exists for one specific reason, to find an appropriate punishment for a crime that a person has been found guilty for. So, you might not need to have a hearing if everything goes 100% perfectly and there is all innocent verdict, because there is nothing to sentence. There is no punishment to give out when a person is innocent. Does that now make sense? I mean, a verdict that is innocent. So I have been accused of, I don't know, I have been accused of stealing a car theft, because I'm an auto thief. According prosecutors, they hold a trial, and at the end of the trial, I have been found innocent. Do I have to go back there again when I'm innocent? Yes or no? Type in right here. We're going to go one step at a time to make sure we get it. So, I've been found innocent of car theft. Is there any particular reason I need to go back to that courtroom? And no. Excellent. So I've been found innocent of committing the crime of car theft. There is absolutely no reason I need to go back. So let's do a second one. So here I am. I was charged with car theft. On top of that, I was also charged with breaking and entering, because I broke and entered the auto dealership, according to them. And after the trial, I was found again innocent on the charge of car theft, innocent on the charge of breaking and entering. Do I have any reason to go back to that courtroom? Innocent again on both of those counts. We're now, yes, okay, very good. That means if I'm found innocent on all counts, there is no reason for any other court hearing. The same is true for this particular case. The difference is mine had one or two examples, theirs has more. So for the fact that SR has 8, if those 8 are all innocent, he has no reason to go back. As far as the ninth one is just a fine. So you don't have a sentence to give out. You can simply state in the verdict what the fine is, or you can state the fine after negotiating with the lawyer. You don't have to drag someone into court to decide how much to fine them. So does that now make sense? Under what circumstances there might not be another hearing? So if they found him innocent or fined him, then we may not know the reasons for that result. If they found him innocent, then the judge will say the reasons in the verdict. Okay, So in the verdict, the judge will say, just like the judge who denied the arrest warrants, there were two different judges, two different AW hearings. Both times they made a decision. They said exactly why they didn't agree with the prosecution. Same thing, except we're now looking at for a trial, and we're looking at for 9 different things. They're going to speak out about each one of those in full detail. The big piece of paper that they're creating. The one that we are going to get is going to be the summary, but they're going to do all of the big ones, and then they're going to summarize it for us. They might say something like, there is room for doubt on points A, B, and C because of A, B, and C, something like that. Meanwhile, they may say something like, because the defendant has confessed to having converted Korean won into casino chips, he is guilty and should pay a fine of blah, 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 according to such and such law. They might say something like that. So it should come out in that verdict. So we will know as long as the verdict comes out, because I would assume that everyone in South Korean media would be very interested in what that verdict is. So we find that out with a verdict. However, we might not need another hearing. Now, let me break down the other 2 scenarios. Obviously, the all guilty scenario, you guys get the fact that there will definitely be a hearing. But let's go back to my example where I've been charged with auto theft, stealing a car, and breaking and entering into the auto dealership to get it. So let's say that I get found innocent on car theft, but guilty on breaking and entering. So they're thinking, yeah, she did break and enter there, but she didn't steal anything. So innocent on one, guilty on another. Do I have to go in for a sentencing? If I've been found innocent on car theft, but guilty for breaking and entering, do I have to go in for a sentencing hearing? Is there a reason for me to go to find out what happens to me next? Yes. Bravo. I think we've got that down now. So yes, because I need to go find out what's going to happen to me. What are my legal liabilities? How long do I have to get punished for that? What is my punishment? How severe will it be? The prosecution is going to ask whatever they want to ask. Probably they're going to ask for the maximum that they can, because again, remember, they're going to pad their request, knowing that padding something means it'll get down from it. They're going to pad it. And the defense is going to argue it down to whatever they can. Then a sentencing will be reached. Usually it's going to be somewhere between what the prosecution said and what the defense said. After a sentencing has been reached, then the job is not quite done. You then attempt to get that suspended. So now I'm going to ask the final question. Did this last bit make sense? Are you following, or should we break it down one more time? This last bit about what happens with a mixed. I feel like I'm in a virtual classroom. Yes, excellent. This makes me happy because it means I'm actually doing a good job when I can explain it. Excellent. In that case, as I said, I'm calling it done. I'm going to call last minute questions right now. One more. If there's nothing, I say good night to you all, or good morning, depending on where you are. And hopefully we will hear back in a timely manner, and hopefully it will be a just and fair decision. For me, the last thing I would say is, as you're thinking about a just and fair decision, do keep in mind that even if there is a guilty verdict on one or more, that doesn't automatically make it completely unjust. It might be less fair, but not necessarily completely unjust, because there is still the possibility of suspended sentence. So you reserve your decision until you find out if there is a suspended sentencing in case there is a guilty verdict. So repeat after me. If I see a guilty verdict, I will not jump to conclusions yet. There is one more step. The step is to see if it's just, is to see if it gets broken down into a suspended sentence. If it does, then the defense has accomplished their mission and justice has been served, because that is a win. There are two types of wins. One is obviously better than the other, but they're both good. As long as the suspicion doesn't ruin his service. Pam always has good points, so we're going to touch upon that really, really quickly. The reason why Pam mentions it doesn't ruin his service is because it depends on how many years it's suspended for. If it is more number of years in suspension, then what happens is that you get moved into non-active duty. SR is almost done with his service, so he will have to leave his current unit and go into non-active duty and do something like public service, i.e. TOP. That's what Pam means. It doesn't ruin his service. If the suspension number of years is not overwhelming, it's not too much, then he gets to complete his service, and he gets to hold on to the merits and the honors and accomplishments that he's received. He'll be able to carry that with him throughout the rest of his life. So the suspension is really where it's all at. If it's just, you'll see a suspension that's very reasonable. And I'll be able to tell you guys when the time comes, is this at least the second best case scenario? If not the first, does this still fall under the one which we consider to be a goal and a win? So at that point, we'll definitely discuss more. If I see guilty verdict, I won't jump to really bad conclusions. Very good. So if there is a guilty verdict, we all know not to jump to conclusions yet, not to think it's unjust yet. Probably unfair, yes, but doesn't necessarily mean it's unjust yet. We then wait to see what's the next process. Do they get to the second goal? Do they accomplish that second goal? That second goal is so important. If they can accomplish the second goal, we know that this was a just hearing. This was a just verdict. So I would hope you would go back with this. Those of you who joined me today, go tell your friends, your mutuals, your chat rooms what you've learned. And again, if there are further questions that come up, let VLM know. VLM on Twitter. You can type in VIP Legal Monitors, or you can simply type in, I think, VLM_TWT. You can also check VLM Instagram and leave comments there. Or if you already follow me, you know exactly how to get to my DM. So, and those who follow Mr. R obviously know how to get to his DM, since he takes a lot of these questions ahead of time. So send us your question. I actually did one other live many moons ago when I was stuck in the front line, I believe. So I think I did one other, but this is my first live in a very long time, the first planned live. Yes, I will be saving this. I did a test run, I believe it was last week, when I knew that I was expecting the case to end soon. So I think it was either last week or early this week. As I said, my days are all blended together. So I did a test run and it worked well. When I ended it, it saved. So hopefully this will save. And if it saves, you all have my permission to take the link and share it all over Twitter if you want. But I do ask those of you who follow my personal IG not to give out my IG to everybody publicly, mainly because I've been many times attacked on my Instagram account, several times. So if anyone wants to share my Instagram IG, do it through your personal DMs, please. Okay, well, in that case, take care. Have a good night, have a good day, and I will see you next time.